Hello, what's up, everyone? Welcome back. So this will probably be my last video for the semester because this is the very last chapter I'll be covering for equity. Okay, so we'll be covering the topic of charitable trust under equity. Okay, so without further ado, let's go. Firstly, the introduction of what charitable equity is outlined in the preamble of Statute of Elizabeth 1601, which is a trust for charity, and in IRC against PEMSL, this case outlines the four categories of charitable trusts known as PAMSL heads. Firstly, relief of poverty. Secondly, the advancement of education. Thirdly, the advancement of religion. Or number four, other beneficial interests. So all of these four are the categories of a charitable trust. So what are the elements then to a charitable trust? What makes a trust charitable? So the elements are three right here, which is firstly must benefit the public, secondly must be exclusively charitable, and thirdly there must not be any personal access. We'll go through one by one, starting with the first one, which is it must benefit the public. So it must benefit, basically must the trust must benefit the public or a section of the public. We can see this in the case of Canada Trust Co against Ontario Human Rights Commission, where this case the trust was held for Protestant British white persons living, I can't remember where. However, it was an invalid trust because it was based on racism as well as religious supremacy. You cannot put a trust that is for, okay, for British people, for people with British descendants, who is a white person who is also a Protestant Christian devotee. So because it does not benefit the public or a section of the public. But this is too is based on racism and and religious supremacy. However, this case is distinguished by the case of Latimer against Commissioner of Inland Revenue, whereby in this case, a trust was created for women of for the for women or Aboriginal Maori people or handicapped people, etc. Ada banyak lagi lah. There are a lot of other categories in this trust, and this trust was a valid one, was a valid charitable one because it did benefit a section of a public, which is either this or this or this or the whole public itself. Okay, that is the first element. Second element, it must be exclusively charitable, which is to say that it must be wholly and exclusively charitable lah. You cannot like it can has to be charitable lah. This is established in the case of Houston against Jones. Lastly, no personal nexus must be held. Personal nexus is there cannot be a bond between the trustee as well as the beneficiary in blood or contract. That means they cannot be related by blood as well as they cannot be related by contract, which is employees and employers. Both of these defeat public benefit because when you have a personal connection to the beneficiaries as a trustee, it defeats the public benefit test lah, senang cerita. Okay, now we're gonna look at the four types of charitable trusts. However, one of these has an exception to the personal access test, which is the first one, relief of poverty. In relief of poverty, you can target small groups of people and still consider that a public benefit. We can see this in the case of Oppenheimer. Mana tadi? Okay, tak apa. We'll just say this lah. Okay, for relief of poverty, you can target small groups and consider that public benefit in the case of Recompton. And the meaning of poverty is outlined both in the case of Colhert's Will Trust as well as IRC against Alhamdulillah, my bad. Okay, IRC against Baddeley. Okay, firstly, in Colhert's Will Trust, poverty does not mean destitute. Destitute means you don't have anything at all. It can merely mean not enough of something. That is the meaning of poverty in the case of Colhert's Will Trust. However, in the case of IRC against Baddeley, the court held that poverty can mean the need for necessity. So there is a difference between this and this because This, you have necessities, but it's not enough. This can mean the need for necessity itself, um, not the ketidakcukupan of necessity. Okay. Okay, in the case of Ray Niazi's will trust, the trust wanted to included building a hostel for low income workers in the area of Cyprus. And the court held that there was a valid charitable trust. However, this was distinguished in the case of Ray Sanders' will trust, which included building dwellings for working class. Now, notice that in this trust, it included the working class, which is not a class with poverty. So basically, there is the orang atas, orang the working class, and poverty. So this Resenders Will Trust included this as well, orang tengah, the middle class lah, I think. So it did not uh, it did not give relief to impoverished people only. It also included the working class, which is not the relief of poverty punya aim lah, sebenarnya cerita. Okay, next. In the case of Dingle against Turner, the testator's wife paid 600 employees. Okay, testator's wife pula. Testator's trust paid 600 employees. Now, notice, in this case, the testator's trust paid 600 employees. Employees is a personal nexus by contract. However, because this is under a charitable a charitable trust specifically for relief of poverty, it does constitute a valid trust because the personal public benefit test and personal nexus test is not required for relief of poverty charitable trusts. Okay, next. Reese Charismatic's Will Trust. This is basically the same thing as Dingle against Turner, which is the same thing but for children. This is for employees, right? This is for the children lah macam tu. Okay, next. Education. We are done with the first type of charitable trust, which basically states that for charitable trust under relief of poverty, this does not apply. Hence why this case exists, Dingle against Turner. Okay. Okay, next, for education, advancement of education. Now, education is not strictly academic. It can also include other skills that is beneficial. And we see that in the case of Ray Hopkins, there was a trust to search for Shakespearean manuscripts, which was considered a valid charitable trust sebab Shakespearean manuscripts do educate literary students, like English students, about the writing of English manuscripts by Shakespeare. Therefore, it constitutes a valid trust. Okay, however, we can see that as opposed to Dingle against Turner, which pays 600 employees, the case of Oppenheim against Tobacco Securities Trust, which states that the trust was for an education of the employee's children, was invalid because employee's children was is included in the personal nexus, and for education as well as the other charitable trusts, it does apply. The only charitable trust that does not apply personal nexus test is the relief of poverty, which is why Oppenheim and Dingle against Turner have opposing court judgments. Okay. Now, what are the types of education that can be constituted as an education for charitable trust? There are two main types of education. Firstly, research, and secondly, artistic and aesthetic education. Which is why we cannot interpret education as strictly academic, because we also have artistic and aesthetic education. Okay, firstly, research. In the case of McGovern against Attorney General, uh, a charitable trust in terms of research is beneficial if three things are fulfilled. Firstly, the subject matter of the research is useful, which is like science, other fields lah, which is useful to the public. Secondly, the acquired knowledge is disseminated among others, which is to say that any findings will be spread out to more people so that it benefits the public, more people know about the research. And number three, it benefits the public or a sufficient portion of the public. Basically the same thing lah. Okay, in the case of Rishaw, okay, in the case of Rishaw, the trust was to create a new type of alphabet to interpret his own book. So if I'm not mistaken, Rishaw is an author who wrote a book in a different language, and he made a trust to create a new set of alphabets for people to interpret his books, which is an invalid trust because it does not help education in any way, shape, or form. The only reason why the new alphabets were to be created was to interpret his books, not for any other purposes, which is why the trust was invalid. However, this case was later distinguished in the case of Incorporated Council for Law Reporting, which concerns the preservation of law books, and we know that law books are very um, important and valuable for law students and anyone in the legal fraternity, as well as anyone else. So it is a valid trust as opposed to reshaw. Next, artistic and aesthetic education. Okay, now in the case of Royal Choral Society against IRC, the court held that in the case of Royal Choral Society against IRC, it concerns the advancement of choral singing, which is apa nyanyian yang ramai-ramai lah in a line and then like in a group semua tu lah. So the court held that education cannot be bound and interpreted narrowly, and the court held that choral singing is included in the realm of education. However, this is distinguished in the case of reopinion, which in this case the testator has a lot of art stuff down, and he made a trust for that studio of his as well as his art stuff to be exhibited to the general public. And the court held that it was not charitable, and even the judge explicitly said that that collection is a part of junk. So even though art is subjective, I guess this is objectively a part of junk to the court lah kot. Okay, we're done with the two first types of charitable trusts. Next, we'll move on to the advancement of religion. So, the definition of religion is outlined in Section 2, Sub 1 of the Charities Act 2001, which concerns the belief of God, gods, or the belief that does not involve a god. Okay, what does this mean? We look at a case law which will explain what a belief which does not involve a god is. Okay, the advancement of religion also includes building and maintenance of religious buildings. And we can see that in the case of Ri Lau Kim Pong settlement, there was a trust that concerns 12 acres of land for the use of a Buddhist temple. Now, the court held that it was valid. That is what is meant by the building and maintenance of religious buildings. Okay. However, it is distinguished by the case of AG against Tipuri Sundari, where in this case the testator included 200 bucks for a dedicated priest. Bukan priest. This is a DT. Okay, so basically, he had a trust, and some of the money went to a dedicated deity, which is one of the gods at the temple, lah, which is not fulfilling the public benefit test, but it is one deity only. So these two cases are distinguished. Okay, in the case of Gilmore against Coates, the trust for nuns working in private is held invalid. Okay, in this case, there was a trust to give money to nuns who work in private. Private is like they don't contact the outside world at all. Okay. However, the nuns, if I'm not mistaken, argued that even though they don't contact the public, their religious rites and religious prayers do actually involve the public and benefit the public because they get the effects macam kebaikan and rahmat daripada doa-doa tu lah. However, it was not held charitable because it did not involve the public directly, so to say, macam tu. And this is distinguished in the case of Ray Hetherington, where a trust for prayers in mass was created. Prayers in mass ni macam you see the church service on Sundays and all lah. That is prayers in mass. So the court held that that was a valid charitable trust because it involved the public, okay, as opposed to Gilmore against Coates. Okay, next. Okay, this is what is meant by belief not involving God. In the case of R. Hodkin and Church of Scientology against Registrar of Birth and Death, the court basically held that the Church of Scientology, Tom Cruise, the Church of Scientology believes in a higher power, but not necessarily God per se. And the court held that that belief, which does not involve God, since it is just a higher power, but it is not God, is included in the realm of religion. Macam itulah. Okay. Now we are actually done with three. The last one is here. Other other beneficial interests. This is it. Okay. In the case of other beneficial interest ni, I don't think we need to define what it is lah. Okay. So we just basically move on to the nitty-gritties. Firstly, in the case of IRC against Baddeley, ingat tak IRC against Baddeley is around there. Mana tadi? Okay, this one. IRC against Baddeley, which is concerning a trust of class within a class. Sekejap. Okay, a class within a class is basically macam ni tau. If I am a testator, I create a will which states that I will have 500 ringgit given to Muslim males living in Shah Alam who practice law. Okay, so each one of these is a class, and when you narrow everything down to Muslim males in Shah Alam who practice law, there is too narrow of a group of beneficiaries for the court to disseminate the or distribute the whatever that I am putting on trust lah, which invalidates the trust. Okay, that is the principle of class within a class in the case of IRC against Baddeley. Okay, in the case of Re South Place Ethical Society, the court held that just because something is beneficial to the public does not mean it is charitable. Because if I'm not mistaken, in this case, it was a trust to build a park for people to like spend time and do their activities. And even though the park is beneficial to the public, it does not mean that it is charitable. It is mainly beneficial. Macam tu. So, can someone build a trust for animal welfare? The answer is yes. In the case of remorse, the court held that a trust for cats, the maintenance of cats is held charitable because it promotes kindness. However, in the case of Douglas, which concerns the building of a dog home, the court held that the dog home cannot block public view. Public view. That means the public can look at the dogs which was contained in the home lah macam tu. The court, orang luar tak boleh dihalang daripada tengok anjing-anjing yang dekat dalam the dog home. So, okay, what about civic amenities? Civic amenities is basically the building of any infrastructure lah. Okay, there are two cases, AG against Shrewsbury Court, which concerns the building of towers and walls, as well as Scottish Burial against Glasgow Court, which concerns the maintenance of crematoriums. Both are valid trusts because it does benefit the public. Okay, lastly, we have the Cyprus Doctrine. The Cyprus Doctrine is when a trust is impossible to be executed, the court will actually constitute something which is as closely as possible to the original intent of the trust. Contohnya, you want to build a trust for the preservation of a particular species of orangutans in the Sabah and Sarawak region. However, you baru tahu yang actually after you have executed the trust, the species in question has already gone extinct. So what the court will do is maybe the court will look at another species that is almost going extinct and instead preserve that species instead, macam tu. As opposed to cancelling out the charitable trust entirely, they will actually try to substitute, yes, not constitute, substitute another trust that is as closely related to the original intent as possible. That is the Cyprus Doctrine. Okay, that is the topic of charitable trust. By the way, this topic has 29, if I count correctly, 29 case laws, which brings our total of this, including our previous video, of cases to 62. So in total, there is at least 62 cases that you need to remember. No pressure, no pressure, of course. But yeah, all the best, and that's about it. See ya.